All please stand for the members of the Judicial and Bar Council. We have Honorable Maria Milagros and Fernan Cayosa, Honorable Jose V. Mejia, Honorable Menardo I. Guevara, representing the Executive Branch, Honorable Justice Aurora Santiago Lagman, and Honorable Justice Angelina Sandoval Gutierrez. Thank you. Please remain standing for the centennial prayer for the courts, national anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Public interview of applicants for the position of Associate Justice of the Supreme Court, vacated by Justice Martin S. Villarama Jr., is now open.
Your Honors, the candidates to be interviewed this morning are Court of Appeals Associate Justice Stephen C. Cruz, Solicitor General Florin T. Hilbay, Presiding Judge Reynaldo B. Daway of the RTC Branch 90, Quezon City, and Court of Appeals Associate Justice Mariflor P. Punsalan Castillo. May I request Solicitor General Hilbay, Presiding Judge Daway, and Associate Justice Castillo to stay in the holding room while the interview of Associate Justice Cruz is being conducted. Thank you very much, Your Honors. Cruz, please occupy a hot seat.
Good morning, Justice Cruz.
Take my seat.
Okay. I'm sure you are well ready for interview. So may I request now Attorney Cayosa to start the public interview.
Thank you, Madam Chairman. Good morning, Justice Cruz.
Good morning, Your Honor.
We have extensively interviewed you not too long ago, just in May of 2014, and I just have a few clarificatory questions. This is with regard to your sworn statement of assets and liabilities, because it appears that you have property in Lucena.
Yes, Your Honor.
You still have property in Lucena.
Yes, Your Honor. It's a family property.
Okay, because the records in the LRA show that this property has since been cancelled in your name.
It's been transferred to a family corporation.
But-
Some of it.
But you still declared it in your SALN?
I don't think so. I just declared properties in my name, if I remember it, Your Honor. All properties in the name of the family corporation.
So is this
I did not.
bungalow property in Lucena still?
Oh, yes, that's under our name, myself and my brother.
Okay. At any rate, it appears in the records of the LRA that this has been cancelled in your name, although we have no information to whom it was transferred.
I have to look into it, Your Honor.
At any rate, is there any significant development in your career as a jurist that you would want the JBC to be informed of, and that would help your application for position of associate justice?
The word significant is relative, Your Honor, and maybe to be safe or on the safe side, what happened since the last interview until now is that I had the opportunity, thanks to the Court of Appeals, to attend a seminar at Harvard University.
Yes, could you tell us something about this seminar?
It's a 2-day intensive course on negotiation, wherein participants are pitted against each other under a certain set of assumed facts. Then they allow you to negotiate and determine whether you could win your cause as against their cause. Basically, it's a set-up situation.
Is this some form of alternative dispute resolution, or?
Yeah, let me explain, Your Honor. It's not an alternative dispute resolution. It's a negotiation wherein you stand at equal footing with the other side of the table. You negotiate with him over a certain issue and win the most issues in your part. Like pay, standard pay, or a price of a project. The other side would negotiate for a lower one, while you, the proponent, would negotiate for a higher pay. So you negotiate and give some, pull some.
You believe that this has some relevance to your duties as a member of the Court of Appeals? And if any significance, what would this be?
Yeah, it does. Although it's not direct, it gives you a very large window to ascertain certain issues that you would want to decide. You would not be limited inside the box, so to speak, but you look at it from outside the box.
On another point, may I just know, while we have a copy of the Judicial Records Division's tabulation of the cases that you have handled for the past 5 years,
Yes, Your Honor.
may I just know how many cases have been submitted for decision that have been assigned to you and that remain pending to this day?
To my knowledge, since the last time it was 35, my last interview, now it has ballooned to 50 to 60.
what do you attribute the ballooning to?
Quantity, Your Honor, of the cases filed.
To be candid, I had the opportunity to look at the records of the other aspirants from the Court of Appeals, and it appears that you do have the most number of cases submitted
Yes, Your
for
Honor.
decision among the aspirants. So what have you resolved to do about this?
I try to keep a target number and decided without sacrificing quality. There are situations wherein you look at it that you would want quantity but sacrifice quality. For myself, I need to balance it that the quantity must conform with the quality of decisions issued out. Thank you, Your Honor.
Justice, that was my last question, so with that I wish you luck. Thank you.
Thank you, Your Honor.
Thank you, Madam Chair.
Thank you so much, Attorney Cayosa. May I now request Attorney Mejia to continue?
Good morning, sir.
Good morning. Thank you, Madam Chair. Good morning po. You were admitted to the New York State Bar in 1982.
Yes, Your Honor.
I think I asked you the last time in your last interview whether you practiced in New York.
Yes, Your Honor. I tried to, but the practice there is quite different from ours.
My question really is, are we now open, or are you agreeable to the proposal that we now allow foreign lawyers to practice in the Philippines?
I would agree with that proposition because the Philippines is not, well, although it's an island, quote unquote, it's not an island. It attracts investors, and international law might come in. With foreign lawyers allowed on certain situations to practice here can contribute to our legal system and jurisprudence. It can, in fact, open our eyes that we are not an island. We are global. Thank you, Your Honor.
Considering that you will have, I think 4 or 5 years, should you be considered for the position, what do you think will be your significant contributions to the agenda of the current Chief Justice?
As propounded by Justice Cayosa, there is quite a dearth of cases filed in our courts, and prime and foremost would be to unclog court dockets. How do you do that? One would be, I guess, I'm not alone in this cause, is to do a paperless practice in applicant procedure. The advent of computers will help us a lot. In fact, we could read to the iPads or computer screens or USB all the necessary pleadings as it is read on paper. And eliminating paper would hasten disposition of cases. Plus the fact, Your Honor, that we could save a lot of trees by not using papers.
Thank you. That was my final question. Good luck again.
Thank you, Your
Justice Cruz, and thank you, Madam Chair.
Thank you so much, Attorney Mejia. I now call on Attorney Guevara.
Thank you, Madam Chairman. Good morning, Justice.
Good morning, Your Honor.
It's the first time that I will be interviewing you because this is the first time also that I am sitting in the JBC.
It's my pleasure, Your Honor.
Justice, in your opinion, what is the present image of the Supreme Court to the general public?
At present, the Supreme Court is flooded with election cases. time is of the essence because elections are next year. People must be, the public must be cleared of gray areas like the qualification of Madam Po, Duterte, and who really would be the final list in the quest for the presidency. The Supreme Court is tasked in accelerating these decisions. It depends upon us, members of the judiciary, to abide by the clamor of the public that they be cleared of the controversies besetting the Republic right now, qualifications of the candidates for the presidency, as soon as possible, Your Honor.
Considering your statement that the Supreme Court is flooded presently with election cases, do you think that the Supreme Court, in disposing of these election-related cases, have to factor in political considerations as well in rendering its resolutions?
I hope not. What the Supreme Court should factor in would be the general welfare of the people, not politics, with due respect, Your Honor.
Justice, from time to time, certain surveys are being made pertaining to trust ratings of key government officials, including the Chief Justice. In your opinion, does the trust rating of the Chief Justice reflect the level of trust of the people on the Supreme Court in general?
The ratings is a factor, but it is not the sole reason to determine a conclusion. The people, on the other hand, should be also open to other factors and then see it as a whole, not on a microscopic stance, but on a bird's eye view.
In your opinion, Justice, if the present trust rating of the Chief Justice, hypothetically, for example, is 25%, do you think that the people in general also carry or give a 25% trust rating on the Supreme Court?
Well, the ratings are really questionable. It's just what? Standards. It's not the true value. So if I am one who reads that, I take it with a grain of salt. You know.
Having said that, in your opinion, do you think that the trust of the people on the institution as a whole is higher than 25%?
I believe so, Your Honor. Our people or the citizens in general trust the judiciary, especially the Supreme Court.
Justice, in your application for this vacant position in the Supreme Court, do you have a personal agenda to bring?
The only personal agenda that I would think of is that every lawyer would want to be in the Supreme Court. That existed when he first enrolled in law school. One day, I'll be there with my career path on the line. It's one of the dreams, really, of a lawyer, Your Honor.
So it's really more the conclusion of a legal career that
Yes,
you have
Your
in
Honor.
mind,
It's a career path.
and you do not foresee yourself doing something else after retirement from the Supreme Court, assuming that you get appointed.
I would say that I'll cross the bridge when we get there, Your Honor.
So apart from putting, the biggest feather in your cup in your legal career, is there any specific innovation that you think you would make when you join the Supreme Court?
As I've said a while ago, one would be the judicial reforms, the paperless litigation or appellate practice.
Yes, I heard that.
Yes, Your Honor, that is the only thing.
Yeah.
Then there are others, but it needs refinement and further study. It's just off the bat. I have two in mind right now, but I am not really espousing it. It's just maybe the Supreme Court could toy on it and make a good thing out of it. Like one, the possibility of a creation of a constitutional court. I don't know the impact of it. Other countries have it. So why not us? Is it applicable to us? There are a lot of questions, but the idea of a constitutional court sticks to the mind. The other is, since there is a clog in the dockets, especially on appeals and appellate practice, why don't we toy with the idea of a limited appeal, wherein certain cases would be final at a certain stage and will only be brought to the Supreme Court on specific matters like national security, first impression, exceptional case, wherein it's to correct an unjust judgment like that, wherein the discretion to accept would be on the Supreme Court, not on the litigant filing the appeal. So basically it's a limited appeal procedure.
Your concept of a constitutional court, the one that you mentioned earlier, the Supreme Court itself is a constitutional court.
I know that. It's
Yes, that's-
blended into it, Your Honor.
So what is this other constitutional court that you have in mind then?
Like what the word says, it only deals with limited jurisdiction.
Such as, for example, what?
Constitutionality of a law, ordinance, or regulation, like what you call this? Qualifications of members of Congress. I know the Supreme Court now is able to do it, and the need for it might not be really that bad. But as we go along the line and through the years, it could be a good discussion. Viability of a constitutional court, its members, powers, and jurisdiction. All I know is that it needs really a constitutional amendment or revision.
Just as your idea about paperless pleadings and documents in court, do you think we're ready for that within the next 5 years?
Yes, I think so, Your Honor, because it's just the use of computers. Everything is there. In fact, the computers, or our computer age, made faxes not necessary. Telegrams are no longer necessary right now. Obsolete. I go along that line, Your Honor.
will you agree with me that while technology is improving and making things faster, it's the ability of our judges and justices to cope up with these advances in technology that is the problem?
I think that's the least of the problem. It's just really teaching them how to use the computers.
How do you intend to do that, Justice? Teaching all
Hands-on?
how to use computers.
Hands-on. I know one way or another, judges would operate a computer. They know how to. They just have, maybe they don't want to, but I know they know. I myself I'm doing it.
Should we make that a new qualification for appointment to the judiciary?
Computer literacy?
Yes.
It's a good suggestion. I would agree with that.
Thank you, Justice. I think my time is up.
Thank you, Your Honor.
Thank you so much, Attorney Guevara. May I now request Justice Lagman to continue.
Thank you, Madam Chair.
Good morning, Your Honor.
Good morning, Justice Cruz. Justice Cruz, yes. As stated earlier, we have interviewed you several times, the last time of which was on May 30, 2014.
Yes, Your Honor.
So, I don't have so much question for you except this one. Justice Cruz, what do you consider as your most significant achievement as a member of the Court of Appeals, which would give you an edge or advantage over the other members of the court who are also applying for the same position in the Supreme Court?
There is no outstanding or significant on the upper degree
Yeah.
to speak of, Your Honor. I am an ordinary person. I study my lesson. I pray to God, and I consider myself among equals, Your Honor.
Yes.
That's all, Your Honor.
So, this is a question, Twitter question, no? Which we received from the Twitter. This is not my question. Does greater transparency in the judiciary, including its budget, compromise the court's independence?
I don't think so. Those matters are really open to the public. The budget, how we decide cases, it's open. It's not a secret. We are not in Mount Olympus and only us see ourselves. People, the people has the right to know how we do things, so long as we maintain our independent discretion on how to decide a case based on law. Yeah.
Okay. On that note, I have no further question to Justice Cruz. Good luck.
Thank you, Your Honor.
Okay, thank you.
Thank you so much, Justice Lagman. Good morning,
Good morning, po.
Justice Cruz.
Good morning, po.
The first question is, have you written or rendered a decision or decisions which reached the Supreme Court and eventually became landmark decision or decisions published in the newspapers?
Offhand, I can't think of anything, Your Honor. I do my job deciding cases in accordance to law, and if it's accordance to law, it's a normal thing to do. No highfalutin decisions whatsoever, Your Honor.
No constitutional issues.
None, Your Honor.
Okay. And next question is a follow-up question of Attorney Mejia. According to you, foreign lawyers should be allowed to practice here in the Philippines. And I think it must be symbiotic. Filipino lawyers should also be allowed in foreign countries, don't you think
Yes,
so?
reciprocity, Your Honor.
Yes, that's it.
Maybe may I add to it, the foreign lawyers could also practice in our courts pro hac vice for that purpose only, not as a general practitioner.
Unless, of course, they pass the bar here.
Yes, of course, Your Honor.
Anyway, you stated a while ago that your purpose, primarily in aiming for a seat in the Supreme Court, is to enhance your career because that has been your dream as a lawyer to reach the Supreme Court. Don't you think that the primary reason should be public service? Career should be number 2.
Your Honor, choosing a path or a career path is relative when I chose, or all of us lawyers chose, the judiciary, that's the public service. It's a career also, Your Honor, along with...
Career is different from public service. So my question is, which will go first and which will go second? According to you, it's the same?
Yes, Your Honor. It depends upon if you practice private law or privately. Public service takes a backseat right because you're practicing law. But when you join the judiciary, public service through the judiciary takes a front seat right, Your Honor.
So public service connotes,
Yes, Your Honor.
success in your judicial career connotes public service.
Yes, Your Honor, because...
But I still think that number 1 priority should be public service, and then number 2 is your career. Anyway, that's your opinion.
I submit,
This is
Your
my
Honor.
opinion. Anyway, a while ago, you said that you establishing or creating a constitutional court in the Philippines will somehow really lessen the load of the Supreme Court, and I agree very well. Because when I was still in the Supreme Court, that's been a topic among justices there many times. Although it requires amendment of the Constitution. And then several justices said that a retired Chief Justice should be appointed as Chief Justice of the Constitutional Court. And we had countries, who have these constitutional courts, especially Egypt.
Yes, sir.
And they explained to us that, in fact, there are more constitutional cases than regular cases. So your recommendation is really well taken, and I hope you can write Congress so that when they propose amendment of Constitution, that will be included. Let us talk of
Thank you.
transparency. When this issue of transparency came about, that was the time that the Supreme Court justices allowed their sal-ends to be examined. If you remember before, there was a resolution by the Supreme Court prohibiting anyone to look into the sal-end of any justice because the reason is obvious.
They may conduct a fishing expedition.
Precisely. But because of this principle of transparency, all sal-ends now of the justices are open. And one of the questions there is, how about deliberation of the justices in division or in bank? There is no transparency. What is your view about this? Should there be transparency when they deliberate, especially in bank? Should there be transparency when they deliberate in the division?
When you deliberate, you are nearing the decision stage of a case. In fact, one would know which justice or how that justice would decide the case. And it will be just finding out the numbers that could preempt the integrity of the decision. So, for that reason, I would not be favorable for deliberations to be transparent, Your Honor.
I agree with you, Justice. In fact, there should be no transparency because during the deliberations, the justices will be participating, the public will know how they vote, the public will know easily, readily, which party will win or lose. So despite the clamor among several sectors during my time, our answer was transparency cannot be granted jury or allowed during the deliberation in the in-bank and even in the division. Concerning the budget of the Supreme Court, I also agree with you that it is transparent. Anybody can inspect our financial conditions here, because many said that the Supreme Court is hiding the JDF, Judiciary Development Funds. And what are these funds? These are the earnings of the courts, especially the trial courts, especially docket fees, and all the income derived from the trial courts, lower courts, and including the Supreme Court. But I think in fact, one of the Congressman Fariñas, wanted to abolish our JDF. Do you think it should be abolished? Why do we have JDF in the first place?
I don't think it should be abolished, Your Honor, because it's a source of funding for our budget, which is really that low. As
Even 1%.
As compared to the other separate powers, the judiciary and compared to the executive and legislative, the judiciary is the least or the poorest of them all. We should be commended that we are looking ways and means to source funds independent of the budget, because ours is really that low and we cannot cope up, especially with the salaries of judges and justices, Your Honor. So we fend for ourselves, and that is I find
and sadly, that is the reason why Congress cannot give the judiciary, higher budget, because they always said we have this JDF. And according to Congressman Fariñas, they will repeal PD 1954, the source of our JDF, 20% of which is for the construction and repair of our courthouses, 80% to augment the salaries of justices, judges, and the personnel. Do you think Congress can repeal that?
Well, if it's a law enacted by them, I guess they can repeal it, Your Honor, if they really want to. But getting the votes is another thing than proposing.
Supposing they get the votes, can they repeal PD 1954?
I think so, Your Honor. It's a law.
And what will happen to the new law when it reaches the Supreme Court?
Yes, Your Honor.
So our JDF will stay forever.
I see your point.
Anyway, the warning is there. So thank you very much, Justice. Good luck.
Thank you, Your Honor. Permission to leave, Your Honor.
Next to be interviewed, Your Honors, is Solicitor General Florine T. Hilbay. Solicitor Hilbay.
Please take your seat. Good morning, Mr. Solicitor General.
Good morning, Justice.
We will start now the public interview again. May I request Attorney Cayosa to start?
Thank you, Madam Chairman. Good morning, Solicitor General Hilbay.
Good morning, Your Honor.
Okay. Interestingly, I looked at your bar examination grades, and I noted that your highest grades came from the examinations in civil law and remedial law, both 96%. Interestingly enough, though, your lowest grade happened to be on the last day of the exams, particularly in legal ethics and practical exercises. May I just know, what are your thoughts on how legal ethics is taught in law school? Or should it be taught at all? Or should there be a modification on how the instruction is done?
Thank you, Your Honor. I remember in the UP College of Law where I teach at, I think about a decade ago, there was a project, the goal of which was to incorporate ethical teaching in every subject. And so the college came up with some modules for how to execute that particular idea. I think, along those lines, that ethical rules, ethical practices should be incorporated into the teaching of every subject. And so it doesn't necessarily mean that we should do away with the teaching of ethics as a separate course. I think on its own it's an interesting academic enterprise, but there should be an equal emphasis on the need to teach the ethical implications of the various subjects of law.
Do you believe that the current method of teaching legal ethics, which is to discuss the issues in legal ethics and judicial ethics and the code of code of professional responsibility and the canons of professional responsibility, would be sufficient instruction to prepare future lawyers to become ethical lawyers?
Thank you. I have never had a chance to teach the subject, and so I wouldn't know the current methodology of the members of the academe who teach the subject. What I do remember is that in my course in legal ethics, it was, I think, for the most part, rule-based. And so, based on that experience, I can provide some comments. And my comment would be maybe, as opposed to a purely rule-based approach to the teaching of the various canons, we might as well go to an experience-based or situational approach to the teaching of the various rules. And so, as opposed to memorizing the various rules, we might as well go straight to various situations where a law practitioner or a judge might be exposed to some questions that would require the application of the rules. I think an experiential approach might assist in ensuring that the students are able to internalize the rules better.
Should you become a member of the court, the High Court, what would you emphasize in order to ensure that the next generation of lawyers whom we produce will be ethical lawyers? There will be some degree of influence on the Legal Education Board. What would you propose?
Well, in my case, Your Honor, if I become a member of the court, I would simply incorporate, fundamental notions of justice in every decision that I render. I think beyond the simple application of the rules of law, we always have to go back to, again, basic questions of justice. And so, in my case, for example, as Solicitor General, what I've done is to post in the website of the OSG the various pleadings that I have personally written, and this would be in those significant cases that I have personally handled. And anyone, I think, who would look at those pleadings would realize the fixation with going back to certain first principles of justice, again, beyond the simple application of the rules.
Now, moving on to another topic, you assumed the helm of the Office of the Solicitor General in August 2014. And less than 7 months ago, you became Solicitor General. My question is, when you assumed, what vision did you have in mind to complete within the time given that you will serve as Solicitor General in order to make a difference in your office?
Well, so far as the administrative aspect of being a Solicitor General is concerned, I made sure that both the legal and the non-legal members of the office's contributions are fully recognized. And so I have aggressively pursued a system of promotions in the office. I think by the time I'm done, I think that will be by end of June, I probably will have been able to promote almost everyone in the office. We have also, well, I have continued the program of my predecessor, Solicitor General, now Justice Francis Hardilesa, of promoting capacity building programs. We have been lucky in the sense that we have been able to obtain the required funding from both the Office of the President and in Congress to send our lawyers to various programs abroad. On the legal side, I'm a big fan of leading by example. I think the lawyers and the administrative staff in the office do appreciate it when the head of the office spends more time than everybody else. There have been instances where I've spent 3 days in the office just to finish a particular work. I've also instituted a policy of transparency. Again, my goal has been to show everyone that this is how I work. These are my personal standards, and that is reflected, I think, in the quality of the work that I have produced, and everything can be seen in the website of the office.
Thank you, Mr. Solicitor General. Now, I'm just curious, before your designation as Acting Solicitor General, you're actually Senior State Solicitor, is it not? How did you manage it, considering that you had to go over the heads of several more senior members of the office, particularly the Assistant Solicitor General?
Yes, Your Honor. I am remarkably conscious of the fact that I am the youngest among the leaders in the office. I think the way I try to, well, I wouldn't say justify, but to show that I have the capacity to lead is, well, number one, by telling everyone that I am unique in the sense that I'm probably the only Solicitor General who's gone through all the possible positions in the office. I've been an associate. There are, I think, 4 categories of lawyers in the OSG, and I have occupied all 4 categories of positions. During the time of Solicitor General Marcelo, I was one of his associate solicitors. During the time of Justice Francis Hardilesa, I was his senior state solicitor, and I also occupied the position of an assistant solicitor general in the sense that I was an OIC of a particular division, and then I became an acting solicitor general, and then a solicitor general. And so I think my experience to some extent would justify my appointment. I've also made it a point to develop, good working relations with the lawyers in the office. Again, I'm conscious of the fact of my youth, and I think it's a testament to the professionalism and competence of the lawyers in the Office of the Solicitor General, that they have gone beyond the fact of mere age, and for purposes of working with me at a professional level.
On a lighter note, I'm just curious, perhaps you're the only Solicitor General also who has taken in so much interest in musical instruments and photography, because I noticed in your SALN, you note that as among the assets that you have, and no real properties to speak of.
Well, I think you can only engage in activities that you can afford. Given that I am a member of the UP Law faculty, I don't have much to spend. and so I've catered my interests, towards those things that I think I can afford. My salary definitely cannot afford, a house in a gated community. I've rented my entire life, and so the meager salary that I have, I've spent on, spent on savings. Is directed towards my savings and on certain interests that I have developed. I was lucky enough to have been taught to play the guitar by my father. I became also interested in photography because I like dealing with technology.
That was my last question, Mr. Solicitor General. Good luck. Thank you.
Thank you, Your Honor.
Thank you, Madam Chairman.
Thank you so much, Attorney Cayosa. May I request now Attorney Mejia to continue.
Thank you, Madam Chair. Good morning, Solicitor General.
Good morning, Your Honor.
You have devoted practically your entire career as a lawyer to being a public servant. Just what motivates you in your work as a public servant?
For the most part, I think, Your Honor, it's temperament. The feeling that whatever it is that you have to do must have some public aspect to it. I myself have tried to explain it, and the only way I can explain it to myself is that is my temperament, and I'd rather follow my instincts. When I passed the bar, or immediately after I graduated from law school, I was able to get some invites from the private law offices, but I knew immediately that I wanted to join the Supreme Court as a law clerk. When I was in first year law school, I read a very interesting book about the work of law clerks in the Supreme Court. It's called The Brethren by Woodward and Armstrong. I was so influenced by that book that I made a commitment in first year in law school that I would try to find a job in the Supreme Court the moment I graduated. And so I was lucky enough to have ended up in the office of one of what I would consider to be one of the most eminent constitutionalists of our time, Justice Vicente Mendoza. And after that, I think I just followed my instincts, and I've always ended up in public service, whether as a member of the academy in UP or as a member of Bantay Katarungan with former Senate President Jovito Salonga.
What to your mind should really be the objective of judicial reforms?
Well, at least, Your Honor, at the level of the Supreme Court, it would have both a legal and administrative aspect. As a legal matter, I would consider the certiorari jurisdiction of the Supreme Court as a special concern, and so I think the court, for example, should decide less cases and devote more of its time towards a few cases with significant impact, rather than deciding a lot of cases. I would lean towards an American model of how the Supreme Court as an institution decides. And so, given my experience as a law clerk with Justice Vivi Mendoza, I'd probably issue more minute resolutions rather than decide the cases in full and make them appear in the Philippine Reports and SCRA. If you look, for example, at the volumes of the SCRA, there would be cases where in 1 week, a week's worth of decisions would cover one entire volume. That would make for and this is just my personal view, a rather noisy jurisprudence. I'd rather that you have a few decided cases that are definitive and clear on the major points of law, rather than a host of decisions, that can easily be taken advantage of by litigants to cite whatever it is that they want to cite to suit their interests or advocacies.
Well, having been with the Supreme Court before and now with your work as Solicitor General, how will you characterize the level of corruption in the judiciary? And what specific measures do you intend to introduce in battling the so-called corruption in the judiciary?
Well, I was lucky enough to have been with a justice of the Supreme Court who is known for his integrity. And so I've never been exposed to those matters when I was with the Supreme Court. My familiarity with corruption-related issues would probably be based on my experience in Bantay Katarungan. I spent 7 years in Bantay Katarungan as a member and then as a vice chair with Senator Salonga and Judge Raul Pangalangan of the ICC. As a vice chair of Bantay Katarungan, our mandate was to assist the Judicial and Bar Council actually in the selection process for the various levels of the judiciary. What we would do would be to send our volunteers from the various law schools in Metro Manila, attend the hearings before the Judicial and Bar Council, make recommendations based on our inquiries. I think we in Bantay Katarungan were pioneering in the sense that we had the institutional support of the various law schools and the student volunteers in assisting the Judicial and Bar Council at the time, insofar as providing some investigative reports on the reputation of various applicants to the various positions in the judiciary.
For my final question, you are a bar top-notcher. You topped the bar in 2000. You see, there are other applicants for the same position and other positions in the judiciary who have taken the bar more than once. Do you think an applicant who has taken the bar more than once is less qualified for the position?
Not at all. I've written a lot about the subject, actually. My position is that the bar exam is simply a qualifying exam, no different from getting a driver's license. In fact, in some of my published writings, I have advocated for bar exam reforms, and one of the reforms that I wanted implemented was to do away with the bar top-notcher tradition. Why? Because one's performance in the bar exam doesn't really have any bearing on one's ability to practice law, regardless of how you define it. It's simply that we have this tradition of highlighting bar top-notchers for some reason, and so I definitely would not consider it, as a judgment on the competence or much less on the integrity of a person if he or she did not pass the bar during the first take. I think you have some famous bar flunkers in history. One of them would be the current presidential in the United States, Hillary Clinton. I think she's a very good lawyer.
Thank you. I said that was my final question. Good luck, Solicitor General Hilbay, and thank you.
Thank you.
Thank you so much, Attorney Mejia. May I request now Attorney Guevara to continue.
Thank you, Madam Chairman. Good morning, Soljan.
Good morning, Your Honor.
I won't go into your qualifications in terms of competence and other professional achievements because I think you have a remarkable one. So I'd like to
Thank you, Your Honor.
propound questions on some other things like your views about the Supreme Court. What, in your opinion, are the most serious imperfections, if any, of the Supreme Court?
Imperfection. Well, for one, I think the Supreme Court needs a new building, and so I'm quite happy that the Supreme Court will soon be transferring to a building of its own. I think it's long overdue. Insofar as other imperfections are concerned, I can't really think of any other than my concern over the certiorari jurisdiction of the court. I have been powerfully influenced by Justice Mendoza on these matters about the need to ensure standards about the way the Supreme Court accepts and decides cases. I remember, for example, in the DAP litigation, which I handled for Justice Francis Ardeleso, there was a question posed by some of the justices about what we think should be done with respect to the certiorari jurisdiction of the Supreme Court. And I hope I'm not divulging any confidences here, but at some point I actually proposed, as part of our memorandum in that case, an inclusion of a proposal for the court to adopt a rule of 7. In the United States, you have a rule of 4, which means that prior to the court accepting a case for decision, you have to have 4, 1 less than the majority for you to have to give due course to a particular petition. I would want something similar to be adopted by the Supreme Court. I think beyond the compliance with the technical requirements for deciding cases, you need to have some kind of a sense of a less than majority of the Supreme Court in bank cases, say 7 or maybe even 5 or 6, so that an initial vote can be had by the members of the court, telling basically the public that we are interested in this case because we think it is sufficiently important enough. And so I think that is a very good filtering mechanism. I'm concerned about the number of cases that the court accepts. So, for example, the notion of a transcendental importance exception to the jurisdiction of the Supreme Court, the grave abuse of discretion clause in the Supreme Court. I believe, and again, this is just my personal view, that there aren't really clear standards that will tell litigants and the public what they are, insofar as compliance with those standards are concerned. And so every time the Supreme Court says, well, we believe that this case is important enough for consideration, then that is the standard. And I do not think that it signals to the public what the rules really are when it comes to the decision in important cases. And so the way to remedy, I think, that particular concern is to have, a rule of 7 or a rule of 5 or 6, so that you have, at the get-go, sufficient number of justices who will tell everyone, we think this case is important enough, and therefore a less than majority number of the members of the court can decide on an institutional basis what cases should be heard and should not be heard.
What about structural reforms, Soljan? Do you think that there is a need for structural reforms in the Supreme Court or changes in policy directions?
insofar as structural reforms are concerned, again, given my concern over the noise in our jurisprudence occasioned by the number of decisions that are published in the court, I'd probably, as a member of the court, ask my colleagues to sit down and really determine for ourselves what our priorities are, both at the division and the bank level, because if with the number of cases that the court decides, there might be some impact on the quality of the decisions. I remember at some point that the court had this objective of zero backlog, and it basically puts a lot of pressure on the justice to produce as many cases as they can. That is a good objective, of course, but there might be an impact on the quality of the decisions. You would want members of the court to have the temperament of scholars as well as the lifestyle of scholars, meaning they should have enough time to sit down and sit back, relax, and think about the big things, because they're creating policies. They're very different from lower court judges in the sense that lower court judges, they are really duty bound, in fact, to simply apply the rules. Whereas members of the Supreme Court, they have the authority to redefine the rules. And the ability to go back to first principles, I think, requires the temperament of a scholar, because that requires you to look forward and see for yourselves what would be the possible implications of certain policy changes in the rules or in the structure of the Supreme Court itself.
Well, that seems to jive with your earlier statement that you would rather see fewer decisions of the Supreme Court, but which set, very clear major points of law. So, do you think that the case of Torre de Manila will fit this mold of a case that will settle a clear point of law?
Well, if you look at the petition filed in the Torre de Manila case, in my view, that was procedurally defective. But again, had the court adopted a rule of 4 or 5 or 6, right? Regardless of whether or not the defects in the petition, so long as you have enough votes in the majority or in the minority to communicate to the public the importance of the case, then that should be sufficient. I wouldn't want the court to be blindly proceduralist. There might be certain cases, of course, where there is a need for the court to decide a particular case notwithstanding the particular defects in the way the pleading was written. But on a global scale, on a policy scale, I would definitely want the court to be strictly proceduralist. In the large number of cases.
Okay. On a lighter note, Soljan, you're 41 years old only. And I'd like to ask you if this young age is an advantage or a disadvantage in your application for a seat in the highest court of the land.
Thank you, Your Honor. I think it goes both ways. Whereas old age can be an advantage and a disadvantage, youth can be both an advantage and a disadvantage. It's just that, well, in my view, and of course I'm biased in this view, the Constitution envisions some kind of a balance in the force of generations. That is why the Constitution itself allows someone who is as young as 40 to apply for for a position in the Supreme Court. Top of my head, a majority of the members, overwhelming majority of the members of the court are in their 60s. I think there are about 2 members of the court who are in their 50s, and no one is in his or her 40s. I wouldn't go so far as to say that that's unfair, but I think that there might be some space for the court for someone who is as young as I am, because I think my generation has something to contribute in terms of the perspective, because I belong to a generation that grew up in the 80s and the 90s, which is a very different information environment. I definitely would say that people from my generation would have a different perspective on certain types of legal questions. But I do acknowledge the fact that my youth can be a disadvantage in certain situations. It's just that, in my belief, it can go either way, either as an advantage or as a disadvantage.
Well, in the event that you were not selected in your first attempt to get a seat in the highest court of the land, and considering further that your term as Solicitor General will end with the term of the incumbent president, what other options are you considering, if any?
I intend, Your Honors, to return to teaching. I am a full-time member of the law faculty of the UP College of Law. I intend to go back. My secondment will naturally expire upon the expiration of my term. I am, in fact, rather excited to go back to full-time teaching once my term is done. My stint in the Office of the Solicitor General has vastly enhanced my experience. I have so many more stories to tell about how the most significant cases that we've handled, that my office has handled, has improved my perspective and my views about law in general and constitutional law in particular. And so if I don't win the lottery and don't get appointed, I wouldn't be really sad, because I have options that I think are really worthwhile and are very wonderful options.
Just one last question, if you may. On a much lighter note, I always subscribe to the view that the most effective worker is one who lives a very well-balanced life, including his personal life. So what can you say about that? Because I noticed that, you're still single. And some people say that when ladies grow old at nagiging matandang dalaga, or guys grow old and still remain single and become matandang binata, they become irritable, they become ill-tempered sometimes. And do you think this has a bearing on the manner in which someone can perform his official tasks?
My single blessedness means, if at all, that I do not have any jealous mistress. I can devote my entire time to my professional work with enough space and time for the things that I consider important: family, music, the arts, philosophy, and so I would like to think of myself as a very happy person. I have no reason to be sad. In fact, in many ways, I am extremely lucky with what I've been able to experience, regardless of my accomplishments. The past 3 years have been unbelievably exciting for me in many levels, and so I think I'm a very I'm a person with a happy temperament. That's how
Thank
I
you
would
very
put
much.
it.
Thank you very much.
Thank you, Your Honor.
Thank you very much. And now may I request Justice Lagman.
Thank you very much, Madam Chair. Soljan, good morning.
Good morning, Your Honor.
This is in line with the last question of Attorney Guevara. They say that life begins at 40. Yes. You are now only 41 years old.
Almost 42, Your Honor.
Oh yeah, almost 42. Okay, let's admit that you're almost 42. If you will be fortunate to be nominated and appointed to the vacant position in the Supreme Court and stay there up to the mandatory age
Yes.
of 70, you will be staying in the court for at least 29 years.
Yes.
They say that those years between the age of 40 and 70 are the most productive and enjoyable years in a person's life. In the court, you will be spending most of your time in the confine of your office, within the confine of the four walls of your office, preparing decisions and resolutions. Do you think you will be happy in that situation where even your social life will be restricted and you might not even have time to meet or look for your partner in life?
Okay,
Do you think you will be happy in that situation?
Thank you for that question, Your Honor. Yes, of course, Your Honor. I think if I am fortunate enough to be nominated by this Honorable Council and appointed by the President, I'll be no different from, say, a Justice of the United States Supreme Court who gets appointed for life, while in good behavior. And so I think the life of a Justice of the Supreme Court is quite parallel with the life of an academic, and I've been an academic my entire professional life. You spend, your entire day reading, researching, and writing. When you get fixated with an idea, you spend, 1 or 2 weeks straight of your life just, focusing your efforts towards the articulation of an insight on law. And so I think to that extent, what I've done in my 20s and my 30s has been geared towards a life in the chambers, so to speak. And so I do not see any significant change in the way I live if I get appointed. It's in fact jives with what I do generally. While I do consider myself a social human being, I certainly don't consider myself as a party person. I'd rather read a book, write, or watch some documentary than party. And so I think given my temperament, my nomination to the Supreme Court and my appointment to the Supreme Court will simply be consistent with my temperament. And so I wouldn't consider it as a personal disadvantage, right? That I am able to do what I in fact like doing, and spending the best years of my life, doing what you want to do. I think that is in fact the gold standard, for almost everyone, that a person be able to do what exactly he or she intends to do for the rest of one's life.
Thank you for that answer, Solicitor General. Now, you are now the Solicitor General. How would you describe yourself in that position?
The same person who was appointed Senior State Solicitor, same person who was an academic, same person who was a public advocate against corruption. The only difference is the added experience and the breadth of perspective that I have acquired as Solicitor General. I have been fortunate enough to have been tasked with certain grave responsibilities by my superiors, and that has certainly accelerated my learning in many ways. But I don't see myself as a changed person, both in terms of my personal views or my philosophy. It simply galvanized, I think, certain ideas that I've always had. I'm basically still the same person with an added social responsibility that is exposed to the public, I suppose.
Okay, so Jen, I'm just wondering, how do you handle stress?
I handle stress by trying to be more relaxed. I think it's yes, Your Honor. Every time I sense stress, I basically meditate internally, and so someone who's been exposed to rather aggressive interpellations during the oral arguments in the Supreme Court, I think it is an imperative for you to be able to handle remarkably well stress in your life. And so, the moment I hear a justice start raising his or her voice, I start relaxing, and so I think that's the only way to cope with it. The more relaxed you are, the more your mind is able to perform well. Just like an athlete, if your muscles are cramped or stressed, then there's no way you can perform at peak levels. And so the moment I sense stress is also the moment that I start relaxing more.
Okay, I remember one time you were featured in the front page of the Daily Inquirer. We were with your picture there while you were surfing. Are you still surfing?
I haven't been able to do that for quite some time, Your Honor.
I see.
Well.
Now, if you will be appointed to the Supreme Court, what do you think, with your experience, what do you think can you contribute to further improve the image of the court?
Well, I think, every associate justice's contribution would have to be on an incremental basis, and that would be reflected on the quality of his or her own decision. Given the fact that I am a scholar, I would consider myself to have certain standards in the way I think and articulate my own views. My personal confidence in the quality of my work is reflected in the fact that I have, in fact, published, online almost all of the important pleadings that I have written myself. I think it's a standard, that I have imposed on myself simply because of my belief that, based on my previous experience, my collaboration with certain mentors, right? I carry with me a tradition of thinking and writing that is of a different standard.
Okay, so Jen, I'm just wondering, what are your thoughts on the so-called judicial activism as a check and balance mechanics over executive and legislative excesses?
Okay. I think, Your Honor, that judicial activism has no substantive content. A person who is a philosophical conservative can be a judicial activist in the sense that, he or she would impose his or her conservative values. A person who is overly progressive might end up being categorized as a judicial activist because of his or penchant for deciding progressive cases. At a procedural level, a person can be considered an activist because of his or her penchant to decide a lot of cases and do away with the traditional standards for judicial review. Or it can go other way. A person can be a judicial conservative because he has very high standards for imposing certain procedural restraints prior to deciding the merits of a case. And so, in my view, it's really very difficult to define what judicial activism means, other than a penchant for going beyond the normal things that judges do.
Okay. My last question. What do you think is the most difficult challenge faced by the judicial branch of government, most especially the Supreme Court today? And how can you contribute, if you will be a member of the court, to address the same?
I think, Your Honor, that in the past 2 decades, the court has grappled with the question of how to deal with the intersection of 2 categories, law and politics. We live in very interesting times. We live at a time when so many people believe that a lot of political questions are in fact legal and constitutional questions. And so there is an apparent tendency to constitutionalize and legalize many of the what would otherwise be political debates in the Philippines. And the net effect of that is an enhanced pressure on the court to deal with what would otherwise be standard, questions for the political departments to decide. And so, this exception, the transcendental importance exception to the adjudication of constitutional questions, the tendency of every Tom, Dick, and Harry to file petitions before the Supreme Court is simply a reflection of that tendency. And so I think the court at this point is still grappling with that particular question. How does it situate itself institutionally, right? In this political and politicized environment, and I don't know. For example, I don't think that the court has already provided an institutional answer to that question. I would contribute to a clarification of an answer to that question. I think through my decisions, I think I will be rather strict at a procedural level. I wouldn't want my personal political views to be incorporated in the SCRA simply because I have the power to decide cases. I believe in a clear separation of legal questions and political questions. As a judge, I wouldn't really want to impose my philosophical views on certain things. I believe in I'm a big fan of privacy. I'm a big fan of democracy. There are a lot of questions that ought to be decided by the people in their private or collective capacities. I don't see myself, as a judge who will impose what Alexander Bickel would call fundamental values, and read those values into the Constitution.
Okay, thank you very much, Solicitor.
Thank you, Your Honor.
Thank you so much, Justice Lagman. So good morning again, Mr. Solicitor General.
Good morning, Justice.
Preliminary lang. Under Rule 7 of the JBC rules, the purpose of the interview, among others, is to determine the applicant's judicial philosophy and moral values. Likewise, the JBC is mandated to determine whether the applicant's loyalty to law, justice, and ideals of an independent judiciary is beyond doubt. Hence, the following questions.
Okay.
Preliminary again. I've been reading your book, Unplugging the Constitution. For my better understanding, what do you mean by unplugging the Constitution? I know the meaning of unplugging, but I don't have any idea. I don't know what you mean by unplugging the Constitution. Unplugging from where?
Okay.
How and why?
Thank you, Your Honor, for the opportunity to explain the title of my book. Almost all of the articles written in that book were written after or during my LLM year in 2004-2005, and so I was fortunate enough to have spent 1 year at the Yale Law School to read about a lot of things and think about a lot of things and write about a lot of things. And so those were the years when I became less plugged into doctrinal discourses. As a lawyer, we are naturally predisposed to doctrinal arguments. Why? Because we are trained in a particular discipline. You can't make an argument without a legal basis. And so when I did my LLM year, I noticed the penchant of the institution to which I belonged at the time for purely political or philosophical discourses, meaning arguments and discussions about law that is not really based on hard law. And so I took advantage of that opportunity in order to develop, a purely normative conception of certain aspects of law. Meaning if a person were totally unplugged, meaning not devoted to an internal understanding of the law, what would be the types of debates that person would have? And so the articles in that book were written with that particular influence in mind, meaning even the themes in that article are decidedly non-doctrinal, right? And so I tried to approach certain legal concerns from a philosophical standpoint, from purely political standpoint, and that is how I would explain unplugging the Constitution. Many of our discourses about the Constitution are based simply on decided cases or on the text of the Constitution. About 10 years ago, my goal was to tell my audience, wait, if we weren't so attached to the decided cases, if we weren't so attached to a purely textual reading of the law, how would that change the way we engage in legal argumentation or engage in legal debates? How would that inform our legal views? And so, the articles in those, the pieces in that book would be conversations about the law from an almost non-legal perspective. Sorry for the long-winded answer.
I think I'll be quoting some portions of your book. On page 154 of your book on the Establishment Clause, an anti-establishment view, you wrote, and I quote, "To the atheists, the experience of reading the preamble is one of ambivalence, if not alienation, because of its invocation of an Almighty God."
Yes.
It seems to me that because these twin words, Almighty God, according to you, an atheist is not included in the phrase, we, the sovereign Filipino people. since, as what you said, atheists are excluded, is it your view that the preamble should be amended or rewritten?
Not at all, Your Honor. I think a core value that a judge should have should be empathy. The ability to look at things from the side of a person who belongs to someone with a minority view. I would consider myself a secular scholar in the sense that one of my research concerns would be the post-colonial status of the Philippines. And so the way I see, for example, the RH law would be a move towards the secularization of the Republic. Several decades ago, conversations about condoms, pills would have been taboo in the public sphere, for example. But today, it's ordinary conversation in Philippine society. We are actually now talking about, say, divorce or even same-sex marriage. And so I see that, Your Honor, as signs of a movement in the force of ideas. And I view it historically. Looking at the Constitution, Your Honor, it's simply a point that the invocation, for example, of an almighty being in the preamble might have some implications for someone who is a non-believer, right? And that is a logical point I am simply making.
But don't you consider that the phrase "we, the sovereign people," includes, every Filipino, no matter what his or her religion is?
Yes, of course, Your Honor.
So, according to you, there is no need to reword or rewrite the preamble?
Not at all, Your Honor. I think one of my research interests is the need to understand, the legalization of religious views in our Constitution. And so, for example, from a policy perspective, someone might want to question tax exemptions for religious entities, but it is included in our Constitution. And so a judge who wants to be faithful to the text of the Constitution will have to respect the fact that not only do we have a religious tradition, but that there are provisions in our Constitution that you cannot deny that are favorable to religious establishments. And again, that's simply because of our colonial history and even our post-colonial experience.
Yes, you mentioned colonial history, colonial mentality. Anyway, the next question is, you also question Section 12, Article 2 of the Constitution, quoted as, "The state recognizes the sanctity of family life and shall protect and strengthen the family as a basic social institution. It shall equally protect the life of the mother and the life of the unborn from conception." You see, it's my opinion.
Of course.
Marriage is the foundation of family. But you want to delegalize marriage. According to you, you find legalized marriage as an unjust institution, and that therefore it should be dismantled from the clutches of law and thus do away with the family code.
Thank you, Your Honor, for the opportunity to explain. My view is that marriage as a legal institution, right, can withstand some updating. I think I am a romantic when it comes to this thing. I always tell my students, one does not need to get married to validate how one feels towards another person. For example, there are a lot of people who are married who do not live, happy family lives. And so my goal really is to try to look at the more fundamental values, I think, that are important to every person. And I think the fundamental fundamental value is the value of belonging, right? And so, regardless of whether or not you are in a married relationship, right, what is more important really is that sense of belonging. And that sense of belonging can extend beyond the marital boundaries. Some people would consider friendship to be more important than marriage in some instances. Some people would consider fraternity relations, sorority relations to be more important. Others would consider other forms of belongingness as equally important. And so, just for the avoidance of all doubt, Your Honor, that is a philosophical view. That is not an internal view of the law. And so, in my experience as Solicitor General, right, we have filed petitions before the Supreme Court based on Article 36. Your Honor. In fact, I've been
We will go into Article 36,
Okay.
Mr. Solicitor General. Anyway, in fact, it is your belief that marriage need not be between a man and a woman or a vagina and a penis. Marriage is merely a text or a word. As a combination of letters, it might be as well considered as a cat. So
Yes,
you
Your
don't
Honor.
believe in marriage at all.
Not that I do not believe in
Because
marriage.
according to it's a mere word and should not be legalized. That's why that might be the reason why you're still single at all, right?
No, Your Honor. That piece is a philosophical piece, Your Honor, and I think, Your Honor, as a philosophical piece that is logically correct articulation of the meaning of the word marriage, but that has nothing to do with my belief in rule of law, for example. I do accept the reality that marriage is as a legal matter, is a fundamental and foundational social institution, regardless of my personal views. And again, Your Honor, the separation of personal views and legal views. In my practice of law as Senior State Solicitor and as Solicitor General, I consider myself to have been entirely faithful to the internal workings of the law. And this brings me back to Article 36 petitions and petitions for declaration of presumptive death. I noticed when I was Senior State Solicitor, Your Honor, that there is an increased prevalence of petitions for declaration of presumptive death, and I realized that's actually a way around, a cheaper way towards getting annulment or nullity petitions. And so I have appealed all RTC decisions declaring presumptive death of a particular person, given my view that it's a way around the law. And well, that is how I suppose I would answer that particular question, that regardless of my personal views, and those are personal views, I have remained entirely faithful to the inner workings of the law, and it's simply reflective of my view that I don't have any right to impose whatever personal beliefs I have, regardless of the status of the law. And I think, Your Honor, it's entirely logically consistent with a person to have a different political or philosophical view from what the mainstream law would require or even impose.
By asking these questions, the JBC just wants to know your judicial philosophy and how your personal views, will be tested in applying or in deciding cases which will reach you, supposing you're already in the court. May I continue, Mr. Solicitor?
Of course, Your Honor.
Also, you stated that the desire to associate and to be with someone must not be legalized like friendship or institutionalized. In short, you want to do away with the family code on family relationships, considering that desire or love felt by anyone is beyond government confirmation. Then you ask, why is the government interested in heterosexual coupling or partnership? Or why is marriage between a man and a woman only? And why the relation with permanence, procreation, and surnames? According to you, it is not the government's business to tell us that only two are okay. Meaning to say, in a relationship, threesome, foursome, etc. are permissible, and they can engage in sex in private and call themselves a family. May I know your comment on this?
Yes, Your Honor. I think I'm rather logically correct when I say that the purely personal aspects of a relationship are beyond government regulation. In fact, if you look at the family code, the purely personal aspects of the family code cannot be enforced through judicial orders. I cannot imagine, for example, a judge issuing a mandamus for the husband to love or his wife, right? And so I think I'm being logically correct. As with respect to the notion of the membership of a family, I would simply go back to the notion of belonging. I think, for example, that a lot of people have various bases for attachment. Again, for example, so for some people, fraternities, certain ties of friendships would be more important than family. And I make no moral judgment with respect to how a person lives his or her own life. Some people would like to live on their own. Others would love to stay in some brotherhood or some sisterhood. I, as a matter of personal view, Your Honor, would respect how a person views how he or she would live. But again, Your Honor, as a matter of law, I simply accept the fact that society recognizes marriage as an important legal institution, and a judge would be performing, or a justice of the Supreme Court would be committing an impeachable offense if he or she did respect that fact. And so this brings me back, Your Honor, to my judicial philosophy, that there has to be a separation between the purely political views of a person or a judge and the legal views of a person. If I may give an important footnote, Your Honor, there's a pending petition for same-sex marriage before the Supreme Court right now, and the comment that I'm filing is one for the dismissal of that petition. Why? Because I believe under the rules of the Supreme Court, that petition ought to be dismissed.
Considering your personal view that marriage has no meaning at all, it's a mere word, so we do away with marriage, we do away with the family code, don't you think that time will come, a man and a woman can have as many partners as he or she desires?
I think, Your Honor,
what kind of society shall we have if there is no marriage? What is your definition of a family, by the way?
By
your
saying,
personal view.
Yes, Your Honor. By saying that marriage doesn't have any meaning, what I'm simply saying is that people should go beyond the form. When I look at a married couple, I don't get happy because of the fact that they are married. I get happy because of the fact that they are in a meaningful relationship. And so the fact of marriage itself, for me, wouldn't mean anything other than a public commitment to live together as husband and wife. But again, Your Honor, I would say I'm a bit more romantic about the way I view things when I say that it's not the marriage that counts, it's the quality of the the relationship that really matters to me. And so, as a person, I am not married, right? But I would consider myself to belong to certain important organizations, like my family and my friends and some other groups. And so it's again a philosophical view of how we should view relationships, not a legal proposal, right? To entirely do away with marriage. I would be crazy, Your Honor, to go out and campaign for delegalization as a legal matter, right? It's a philosophical piece, again, Your Honor, which is an invitation for people to a more honest discourse about our institutions.
Mr. Solicitor General, if marriage is not regulated or legalized, so what will be your definition of a family?
I think, Your Honor, that marriage is, as a legal institution today, is actually a
from your
mix.
personal beliefs or views.
The way I see it, Your Honor, marriage is an amalgamation of various forms of regulation. If you look at the family code, marriage regulates personal relations, property relations, filial relations, the capacity to transmit property, inheritance, the capacity to transmit certain cultural values, certain personal values. What I'm simply saying is, as a logical matter, those forms of regulations can be interrogated individually and separately. And so I view marriage as some kind of a Lego sort of an institution. There are so many attachments to the institutions, and you can take out one particular form of regulation, say for example the relationship between a parent and child, and create another code for that particular relationship. You can create an entirely separate code for the property relations between a husband and wife. And so when I say that it's a code, what I'm simply saying, Your Honor, is that logically, just like any other code, it's composed of various it's composed of various categories.
Two last questions. If marriage is deregulated, no law to govern marriage, the persons in a relationship can just say, it's over. This is in your book. It's over, quote unquote. In short, no separation, divorce, or annulment proceeding is needed. Therefore, the determination to continue or not with the relationship should be left to the individual. There will be no laws concerning divorce, separation, etc.
Well, that is simply the logical consequence if you deregulate marriage. I have, in my public speeches and writings, Your Honor, openly advocated, again, as an advocate for deregulation of entry and exit mechanisms related to marriage. And again, that is born out of my firm belief that what really matters is the meaning that is attached to a relationship by a person. It's not necessarily the legal form that is important. I might be romantic in that aspect. Again, that is purely a political view and not a view that I would espouse as a judge, because as a judge you definitely wear a different hat. As a judge you deal with internal law, not external law. There's no opportunity for you to engage in philosophizing outside the law if you are a judge. And so as an academic, I have a remarkably wider breadth remarkably wider flexibility in the way I approach things. But as a judge, you deal with very high level of constraints. And again, Your Honor, I would think it to be unprofessional of a judge to apply a law beyond what the rules impose.
from your personal view, if there is no marriage, if marriage is not regulated, all children born of couples without marriage will be considered legitimate?
No, Your Honor. What I advocate again is for a separation of those categories. Again, you can have a separate code for the determination of the legal status of children. I'm not advocating that children be declared illegitimate, just because they are born. And in fact, my position in a particular case is tilted strongly towards the protection of the rights of children and foundlings.
So this, in sum, this is unplugging of the Constitution and getting away with the family code. Anyway, in the event you are appointed as Associate Justice of the Supreme Court, you will take an oath, and this oath will complete the appointment. And in this oath, but first, I cannot understand this. Your personal views, how can there be a demarcation between your personal views and the laws?
I think it's a core, Your Honor, value of the judiciary. It's an important, an indispensable requirement, right, for a judge to separate his or her personal views from his legal views. I might have different policy views over dinner conversation or coffee, right? But the moment I wear a particular hat, the hat of a judge, I take on a professional obligation to decide on the basis of the facts and the law. In the same way, for example, that I would consider it unprofessional for someone to decide on the basis of, say, one's views on biology or religious views as a way to decide cases. I would consider it entirely unprofessional of me to decide purely on the basis of my philosophical views. I certainly wouldn't want judges to decide on the basis of the fact that they are Muslims or Protestants or Catholics, right? I would impose the same standard on myself and require a separation of one's personal views from one's legal views.
Last question. As what I said before, you will take an oath, and in oath you are nanunumpa. In English, you are swearing na aking itataguyod at ipagtatanggol ang saligang batas ng Pilipinas na tunay na mananalig at tatalima ako rito. At susundin ko ang mga batas, mga kautosang legal at mga dekretong ipinaiiral na may sadyang kapangyarihan. How can you itaguyod and defend the Constitution considering your personal views? And how can you believe or obey the laws when you are doing away with the family code? Meaning to say, maybe personal views can intertwine sometimes with these realities, Constitution and the laws. Don't you find it intriguing, difficult, or very complicated?
I would find it curious, Your Honor. It's a matter of curiosity for me. But I think the most important reflection of how I articulate my beliefs is in how I have performed as Solicitor General. And as Solicitor General, again, I invite everyone to look at the things that I've done, the pleadings I have written, the way I have argued, and I am confident that anyone who searches and looks and analyzes would come up with the position that everything that I have done is consistent with my views of internal law, not external law.
But I still believe you will carry along with you these personal views when you reach the Supreme Court. And I hope, you will just depend on the Constitution, the laws, but not on this book. You have unplugged the Constitution. How can you respect it and obey it, especially?
Again, Your Honor, What I'm saying is it's a metaphor for an invitation for a conversation about our constitutional values outside the doctrinal framework. And I think in the academia, Your Honor, that is an important value that we should treasure, the ability of academics to go beyond the traditional boundaries. But again, of course, as a judge, you are bound by a different code of conduct. You cannot just say anything you want to say. You cannot believe anything you want to believe. As a professional matter, you have to perform based on work on the basis of the facts and the law.
Last word, Mr. Solicitor General, I hope time will come that you will believe in the sanctity of marriage so that someday we will see that you have a spouse. Thank you.
Thank you, Your Honor. Am I discharged?
Thank you. Like a coffee.
Number 3 in the list, Your Honors, is Presiding Judge Reynaldo B. Daway of the RTC, Branch 90, Quezon City. Judge Daway.
Good morning, Judge.
Good morning.
So, to expedite matters,
Justice. Good morning, Your Honors.
may I now request Atty. Cayos to start the public interview of our applicant.
Can I ask permission to use this?
Yes, by all means.
I have a bump stomach and yes. Thank you very much, Your Honor.
Thank you, Madam Chairman.
Justice Cayosa, good morning.
Good morning, Judge Daway.
Yes.
We have previously interviewed you in 2013 when you applied for the Court of Tax Appeals, and you were in fact shortlisted. You were also shortlisted for the position of Associate Justice of the Supreme Court in 2014. And you are now applying for the same position. And I only have one question. When you were shortlisted for the Supreme Court, your nomination raised not a few eyebrows. How would you respond to the comment that an RTC judge should first aspire for the courts of the next level, particularly the Court of Appeals, the Sandigan Bayan, or Court of Tax Appeals, before he is to be considered or he should aspire for a slot in the Supreme Court? Your comment.
Your Honor, my humble opinion or submission. The Constitution provides that the one requirement for being Associate Justice of the Supreme Court is that one should be judge of a lower court for at least 15 years. And I had been an RTC judge for more than 27 years. At that time, I was an RTC judge for more than 25 years or more than a quarter of century at that time. So my answer there was that I was not amiss also in applying for the appellate courts. As correctly pointed out, ma'am, I had been also considered before. In the year 2004, the then President did not also appoint me. But as I previously said, there was an opportunity. And I said that probably it might be God's will that I may get it previously. But I was shortlisted, and that was an answer to our prayers, and it's really extraordinary. But it's really a miracle from God if I ever get this appointment. So I believe, Your Honors, that I represent in a big way the judges of the lower courts who do not also get appointed because the President is not minded to appoint them. But since there is this opportunity that was given to me and I was placed in the shortlist, And this time around, there were endorsers again who thought that probably I should be given this second chance. So I placed my conforme to that, and I believe, Your Honors, that with my experience, there are equivalent experiences that I also had being members of 4 subcommittees that drafted special rules of procedure in the Supreme Court, where I had the opportunity to speak and discuss with justices regarding certain provisions in these draft rules, which were promulgated eventually by the Supreme Court. And I had also experiences where I have been lecturers also sometimes. There was one occasion I was a lecturer before the justices of the Court of Appeals on financial rehabilitation, Your Honors. And I think they also know that that 27 years as RTC judge is something that that is not ordinary, Your Honors. That's my humble opinion regarding that.
Okay. Now, there are other vacancies in the appellate courts. In fact, there are going to be vacancies in all of the appellate courts this year, in the CTA, in the Sandigan Bayan, and in the Court of Appeals. And there will be 2 others also for the Supreme Court. Would you be inclined to apply for any of the mentioned appellate courts, including the Supreme Court, again, should you not be successful in this bid?
I think I will take my chances with the Supreme Court, Your Honors, and I'll pray to God that the Lord will give it to me.
Since the last time we met you in 2014, anything that you feel the JBC should highlight as part of as among the highlights in your career that you would want to mention to us? I would give you this opportunity.
Your Honors, my personal data sheet that I submitted is updated. There are some new matters that are included there, like the various lectures that I rendered during the time, and then the international conferences, 3 international conferences where I was invited either as speaker or lecturer or participant. I think that's all, Your Honors, that I wish to highlight, Your Honors.
My last question. It seems that notwithstanding the fact that you are busy in the lecture circuit, you manage to maintain a 0 backlog. How do you? And there are cases that come in, and there are cases that are submitted for decision. How do you manage that?
I give priority first to my work as in the judiciary before I give time to these lectures, Your Honors. That's how I do it. It's a matter of allocating precious time resources in my being able to lecture apart from my attaining 0 backlog in my court docket, Your Honor.
As I mentioned, Judge, that was my last question, and we have extensively interviewed you before, so with that, I wish you well. Thank you.
Thank you very much.
Thank you, Madam Chairman.
Thank you so much, Attorney Cayosa. May I request now, Attorney Mejia, to continue?
Yeah, thank you, Madam Chair. Good morning, Judge Daway. Just a few questions. When you were shortlisted the last time, there were at least 2 lawyers who approached me and told me that while they do not, and apparently these lawyers are appearing in your sala, while they do not doubt your integrity and your academic capability, they said that you have a tendency to postpone and reset your cases at the last minute, and that you are often not in court on time. I just want to hear your side in that respect.
Your Honor, the postponement at the last minute many times is caused by the scheduling of the subcommittee hearings that I had. I had this since 2006, Your Honors, if I recall right, up to last year. So if there is a subcommittee meeting, I had to postpone this many times. Regarding also the fact that I come sometimes late, there are some instances, Your Honors, where I also come in late because sometimes I'm not feeling well, Your Honors, but later in the morning, I thought that probably I'll just go in late. Otherwise, I take the day off when I'm not feeling well, Your Honors. But lately, I've been doing my best to be calling my cases at 8:30. I do my best to be there at 8 o'clock. I attend the flag raising ceremonies, Your Honor, at 7:30. No, before 8. My staff are here, Your Honors, and I asked them if anyone who wants to come with me, and they said they want to come with me to give me moral support, Your Honor. So I'm saying this because this is something that I've been doing lately, Your Honors.
Thank you for the explanation, Judge Daway. Let me accommodate some of the tweeted questions, if you do not mind.
Yes, Your Honor.
This is from, well, I will not mention anymore the one who sent this, but the question is, does greater transparency in the judiciary, including its budget, compromise independence?
I think, in a way, Your Honors, greater transparency. There's a correlation between greater transparency in the budget and independence, Your Honors, because you're transparent in your budget, then you can also be more independent. Although the Constitution provides that every member of the judiciary must have also independence as one of his characteristic traits.
Another related question, Judge Daway, is, do you think it's unethical for a judge to accept special allowances from LGUs? Does it weaken his independence?
I believe, Your Honors, that the allowances from the LGUs are so authorized by law. But how I wish, Your Honors, that judges would not receive this, and that the appropriation for this be included in the budget of the Supreme Court, Your Honors.
Thank you. That was my final question. Good luck again, Judge Daway, and thank you, Madam Chair.
Thank you very much. Yes.
Thank you so much, Attorney Mejia. I request now Attorney Guevara to continue.
Thank you, Madam Chairman. Good morning, Judge. Good morning, Judge. Yes.
Good morning po, sir.
Yes, Judge. I noted that, as mentioned earlier, you have a zero backlog in your docket, court docket. But I also noted that sometime a couple of years ago that you were reprimanded by the Supreme Court for your inaction in a certain case. So could you please explain to us the circumstances surrounding this particular incident?
It's a case involving one, if I recall right, sir, it's a case involving one who had a condominium. And he charged his client association dues to the point that the association dues were already much, much higher then there was a very high amount that he led him to foreclose the condominium. Now, I issued, I think, I'm not so sure about that, if I issued a injunctive relief. But then there was a rule that this should be decided within six months. Now, the plaintiff tried to get evidence through documents from this, the defendant, the one who made this complaint against me. And he didn't want to give it because he said it got lost. But I said that I made a ruling that there is no reason for him to claim that because the other party was contesting this. And it dragged for more than 6 months. And he filed a complaint against me because he did not want to he did not first file a complaint, but he alleged delay on the part of the plaintiff and also on the part of the court. I made a ruling that there is no delay considering the peculiar circumstances. Then he filed a complaint before the Supreme Court, and they said that I should have decided that within 6 months, but then they reprimanded me. But I accepted that reprimand because I was then being considered in the Court of Tax Appeals before, Your Honor. I did not anymore file a motion for reconsideration. But if the Lord God will allow me to be appointed as Justice of the Supreme Court, I think that rule regarding that, I will bring it up to the Supreme Court and bank so that that rule probably will be amended so that judges like me will not also suffer the same fate.
In addition to that proposal that you would like to take up with the Supreme Court in case you get appointed, is there any other agenda that you would like to bring with you in case you get appointed to the Supreme Court?
There will be many.
What are your plans?
There are many plans, Your Honors, because I've been a judge for a long time, and I'd like the Supreme Court to take a look also on other matters that they have that are so strictly applied against judges, Your Honors. And God willing, I will be in a position to speak for the judges also, Your Honors. Then there are about 1,000 RTC judges all over the country if I got the records right, Your Honors.
Can you give us a couple of these particular issues or topics that you would probably bring to the attention of the Supreme Court on behalf of the many trial judges across the country?
Like, for instance, Your Honors, the matter of the certifications, I think there should be something there regarding there should be some qualifications regarding the monthly certifications that we sign every month for us to have our pay, Your Honors, and several others, Your Honors, which I'm sorry I could not just think of right now, Your Honors. And maybe it will be it will look trivial to the Supreme Court, but for judges like me, these are big matters, Your Honor.
Judge, how's the state of your health at present?
I'm in good health, Your Honors, by God's grace. I walk a lot, and I'm okay, Your Honors.
Yes, Judge, considering the very stressful work of a judge, and presumably it will be more stressful when a judge becomes a justice of an appellate court, how do you normally cope with stressful work or stress in general?
I I have to do my work in the courtroom only, Your Honors, and during Saturdays and Sundays, I walk in the subdivision where we stay, and I go out with my family, Your Honors. And that's the way I survived the 27 years as RTC judge, Your Honor. I know for a fact that some RTC judges do not survive it. Just not recently. A 50-year-old died. That's what I heard in office. In Quezon City before, someone who's at 60 died while in office. So we have to be able to do something to also de-stress ourselves from the kind of work that we have, Your Honors.
Thank you, Judge. I have no further questions for you.
Thank you very much.
Thank you so much, Attorney Guevara. And now, may I request Justice Lagman
Thank you very much.
to continue.
Good morning, Justice.
Good morning, Judge. The record shows that we have interviewed you last May 30, 2014, and in fact, you were included in the short list.
Thank you, ma'am.
So we also interviewed you in 2003 and 2001. So I find no reason to further grill you on your qualifications. Thank you very much, and I wish you luck.
Thank you very much, ma'am. You're so kind.
Thank you very much. You are very lucky. I don't have any question also, Judge. Good luck.
Thank you very much, ma'am. But can I say one piece for you, ma'am? First of all, ma'am, I would like to say thank you to all the council for having included me in the shortlist last year. I hope and pray that I'll have another chance to be considered by the President for appointment. And I know it will be a miracle from God, but miracles do still happen up to now. Thank you very much for your time, Your Honors.
So, good luck.
Thank you, ma'am. God bless.
Dami yung dami kasama. Jojo, thank you daw.
Ang mga nagsabi doon sa nagtawag doon sa kanya sa lack of material dance kasi
Last na po.
ito na naman lack of material dance.
Last na yun.
Sumili po kanina sila Justice sa Skuna, may kasamang mga foreigners. Kasi Justice para nanood ng konti, pero nandoon lang sa likod.
Yung kay Hilbay, Solicitor General.
Ay, gano'n lang ho. The interview is being conducted. Last to be interviewed, Your Honors, is Court of Appeals Associate Justice Mariflor P. Punsalan Castillo.
Good morning, Justice Castillo.
Good morning.
Ready for interview after the long wait. Okay, may I request Attorney Cayosa to start?
Thank you, Madam Chairman. Good morning,
Good morning,
Justice Punsalan Castillo. I noted that the last time you applied for the Supreme Court was in 2010. Since that time, there were several vacancies. In 2011, there were 2. In 2014, in fact, actually, 2012, there was another one, and in 2014. But this is the first time that you have reapplied. What made you decide to reapply now, and why? What took you so long to reapply again?
Because during the interval, I was trying to lower down my docket, and I was able to successfully have a zero docket now. And Justice Javier prevailed upon me. She nominated me for the position, so I'm here now.
Why do you think she nominated you? She could have actually applied herself, but she decided to nominate you.
She said I deserve it and that I have all the qualifications and none of the disqualifications. Those were her words.
Thank you, Justice. Now, I guess there was an opposition to your application back then, and you surmise that it is the same person who is opposing now. What are the dynamics of your relationship with your brother-in-law?
No, actually, it's a family problem. He was able to. We filed civil cases against him for reconveyance of property, annulment of deed of sale, annulment of titles, because he was able to transfer to his name 67 titles of land from my father-in-law, who is now deceased. He was able to transfer those titles to his name by falsifying some documents. We also intend to file falsification charges against him. But it's my husband's family, not me personally.
Have there, considering that you are family members, have there not been any efforts to try to, resolve this issue?
There have been, but he's not amenable to any compromise.
So if you say that this is a purely family matter, which involves your in-laws, but you're being dragged into it with this opposition, and wouldn't this also be a concern later on that should you be appointed to the court that he will constantly raise an issue of your integrity if the issue of those cases will not be resolved yet? You will constantly be dragged. So unless these things are resolved, it may posture as a problem, a continuous problem on your part.
Well, for me, as long as I'm innocent, as long as I have fully explained in my comment the circumstances, and that those are just internet articles and baseless. So I have nothing to hide. I have nothing to be afraid of.
How do you manage? I noticed that in the submissions that you made that your husband is a politician.
Yes.
How are you able to maintain your independence and act on cases independently, notwithstanding the fact that you have a husband who is involved in politics?
From the beginning, my husband and I reached an understanding. We decided that we belong to two different worlds. He belongs to the political world, and I, on my part, am very devoted to my job. And we agreed that neither will intrude upon the other. So far, so good.
Justice, are you involved in any particular committee in the Court of Appeals?
I am the chairperson of the Ethics Committee.
Okay. As chairperson of the Ethics Committee, how have you helped ensure that the ethical standards are maintained in the Court of Appeals? How do you conduct investigations involving members of your court, and to ensure the public that this is, because I know it's confidential, but that this is above board?
We are 5 in the committee, and then when a complaint is filed before our committee, we call the person and we allow him or her to file her comment, and then we deliberate on it, and then we make our recommendation to the presiding justice, and then it will be the presiding justice who will endorse our recommendation to the court administrator Prosecutor's Office.
Throughout your chairmanship of the committee, has there anyone been sanctioned?
Yes, a lot.
A lot. And has this also helped improve, how the judges or justices conduct themselves in the Court of Appeals?
Again, please.
How has this improved how justices conduct themselves in the Court of Appeals?
Well, I think the employees of the Court of Appeals are aware that we really mean business, and that, but so far we have not received any complaint against a fellow justice. Only the personnel of the Court of Appeals.
Should there be a complaint against a justice, a fellow justice, particularly with respect to their morality? How would you deal with it?
I think it will not be referred to our committee at all. I think it will be the office of the, yes.
But what if it is brought to your committee? What would be the proper procedure for you to undertake?
I think we would invite him or her and inform him of the charge or accusation against him. And then we will give him his day in court.
But I thought you said that you have no authority to act on this.
Yes, but if that happens, but now, as of now, there has been no complaint yet against a fellow justice.
Would you be inclined to forward the same immediately to the Supreme Court?
We will forward it to the presiding justice, and it will be the presiding justice who will endorse it to the Supreme Court.
So what if the endorsement is not made? If it sleeps there?
I think he has to, but the PJ has to, because everything will be in paper, on paper, so we will make our recommendation on paper, and then there is a space there for his approval, so I think he has to. It's mandatory for him to act on it.
How do you treat, when it comes to personnel, court personnel, how do you treat anonymous complaints that would give some degree of information that would allow you to proceed with an investigation, even if it's an anonymous complaint?
That is quite hard if it's an anonymous complaint, but we can make some fact-finding investigation. We can ask around. That's the first step if it's an anonymous complaint, but usually it's not. Usually the complaints reaching our committee involve quarrels, petty quarrels, or dishonesty among the employees themselves.
So seldom does it happen that there are complaints regarding morality of your
only once, I think, but it was filed by a fellow employee.
Okay. My final question, Justice. Why are you taking an interest? Of course, you were endorsed by Justice Ami, but I'm wondering why the special interest right now to aspire for the Supreme Court.
Ma'am, I think I'm not speaking for all justices and judges, but I think majority of us, it's our dream to be a member of the highest court of the land. It's an honor.
As I mentioned, that was my last question. Good luck, Justice. Thank you. Thank you, Madam Chairman.
Thank you so much, Attorney Cayosa. May I now request Attorney Mejia to continue.
Thank you, Madam Chair. Good morning.
Good morning.
Justice Castillo.
Good morning, Your Honor.
Just a few questions. Yesterday, one of the applicants mentioned and suggested that one of the ways to radically hasten the disposition of cases is to do away with the motion for reconsideration. What are your thoughts on that?
I think we cannot do away with the motion for reconsideration because we have to allow the judge or the justice or any tribunal or quasi-judicial body to correct itself, to have a chance to correct itself.
My next question is a tweeted question. Apparently, the public is monitoring and watching our proceedings. What is your religious belief? Does it affect your disposition for certain cases or for a certain case?
I'm a Roman Catholic, Your Honor, and well, of course, religion should not be, it has never been a consideration in deciding cases. Cases should be decided based only on law and jurisprudence. So, it's purely personal on my part, my religion, but I will not allow it to interfere with my decision making.
Are you in favor of mandatory legal aid service? How about a tax incentive for legal aid lawyers?
Like the senior citizens, I think we should also give a tax incentive, even a small one, to counsels de officio.
That's all, and good luck again, Justice Castillo.
Thank you.
Thank you, Madam Chair.
Thank you very much. May I request now Attorney Guevara?
Thank you, Madam Chairman. Good morning, Justice.
Good morning.
Justice, you earlier stated that, like most judges and justices of appellate courts, it will be a great personal honor to cap your career by being appointed in the Supreme Court. Obviously, because of the prestige of reaching the highest court of the land. Could you please tell us if that is the only motivation for you to aspire for a seat in the Supreme Court?
Well, I think I have already proven my worth as a judge, and I want to leave an imprint, and I want to have I want the honor to be able to contribute to case law.
Other than that, do you have any personal agenda, let's say innovative changes that you'd like to introduce into the Supreme Court once you get appointed to the position?
I think I will just continue to do what I am doing now. I will strive to finish my cases as I will try to finish as many cases as possible, but quality, of course, should not be sacrificed for quantity.
The records before me state, Justice, that you have a 100% affirmance. Is that correct? I mean, your decisions in the Court of Appeals being affirmed completely, 100% by the Supreme Court?
I think there's a certification to that effect by the CAMIS of the Case Management Office of the Court of Appeals.
Well, I'd like to congratulate you for that, Justice.
Thank you, Your Honor.
But, can you just inform us of any decision personally rendered by you which might have become case law or a landmark decision of the Supreme Court, if you can remember any?
As of now, I cannot remember any. What I know is that there have been only a few cases appealed to the Supreme Court, which I decided. Just a few.
Yes.
But I cannot remember anymore.
I see. And all of these were affirmed by the Supreme Court.
Thankfully, yes.
Justice, you have been in the practice of law for 36 years, according to your personal data sheet.
Yes, Your Honor.
Don't you feel any sense of approaching a level of burnout, if you may say so?
Not yet. I'm only 61, so I consider myself still young. Young at heart and young in mind.
All right. Well, that's good to hear, Justice. There's a certain light question here coming from the public through Twitter. And the question says, did you happen to watch the last Miss Universe pageant, Justice?
Not the whole, just the portion where the the MC committed
made a mistake.
Yes,
but during the interview, I didn't see it myself, but during the interview of our representative to that pageant, I think a question was asked to her about the presence, if let's say U.S. military bases would be restored in the Philippines, how would you feel about it? And her answer was, we had a long history of friendship with the United States, and very casually she said that she would welcome U.S. military bases again in the Philippines in case a move towards that end is taken by the Philippine government. So the Twitter question says, if you happen to meet this contestant of ours who's now Miss Universe, what would you probably tell her regarding that answer?
I would tell her that it is unconstitutional. I would tell her it is unconstitutional.
I have no further questions for the Justice. Thank you very much.
Thank you so much, Attorney Guevara. And now may I request Justice Lagman. It's your turn.
Thank you very much, Madam Chair. Justice Castillo, good morning.
Yes. Yes, ma'am.
Questions here. Justice Castillo, what are your thoughts on moral fitness as one of the criteria in selecting the members of the judiciary, most especially members of the Supreme Court?
Well, it is definitely a criterion, the moral fitness.
So
yes, because we have seen already what happened to those judges who were dismissed based on immorality and questionable transactions. So, and we must always remember that we are deciding sensitive cases, and we should be able to decide without fear or favor.
Okay. If you are a member of the JBC, how are you going to determine the moral fitness of an applicant?
Well, you will have at your disposal our personal data sheet, the history of our employment, and I suppose you have questionnaires circulated, yes, in the Court of Appeals or in other offices. So I think through those means you can already assess whether an applicant is morally fit or really qualified for the position.
How about delicadeza, Justice Castillo? What do you use the meaning of delicadeza?
Well, if, for example, in a case you are related to one of the parties or the counsel, I think it's you really have to inhibit yourself to avoid any impression of bias. That's one aspect of delicadeza. Inhibition. Another is, of course, there are so many limitations on members of the judiciary. We are prohibited. We're not really prohibited, but we cannot go to places like casinos. It's also delicadeza not to go to those places even if nobody sees you.
Okay. What is your opinion on the practice of some judges and justices of inhibiting themselves from trying a case on the ground of pressure from influential people?
I don't think it's a ground for inhibition, because when you become a judge, you must be ready to be under pressure.
And how do you handle pressure in your work now as a member of the Court of Appeals?
I play the piano or the guitar depending on my mood. I read books on my Kindle. I watch YouTube. And I go to the grocery.
How do you handle a situation when a very influential person For example, somebody who helped you in your appointment talk to you and ask you to decide a case in his or her favor or in favor of his or her constituents. How do you handle that situation?
Maybe it's like you're referred to an utang na loob?
Yeah.
Like that. Oh. I think, as a judge, at the end of the day, it will be my responsibility. If I affix my signature on something, it will be my responsibility alone and nobody else's. So, when you say utang na loob, I think, well, in my case, I have been appointed by 4 presidents already, starting from President Marcos, President Ramos, President Estrada, and then President Arroyo. But I think I have already repaid my utang na loob by being a good judge, by doing my job well. I think that's my concept of utang na loob. I don't have to give in to the pressure or the request of somebody to whom I owe my appointment.
Now let's go to another point. What are your thoughts, Justice, on judicial activism?
Reform?
Yeah, judicial activism, which is being used by some members of the judiciary as a mechanism or as a check and balance on the perceived excesses of the legislative and executive branches of government.
Like in what aspect?
Judicial activism is that the personal feelings or the personal belief of the judge making the decision is used as a basis in deciding a case.
Not based on law and jurisprudence?
Yes, based on law and jurisprudence, but the judge, the personal feelings, the personal interpretation of the judge on this, based on certain issues presented before him, is included in the decision. That is what they call judicial activism.
His personal opinion.
Yes, the personal opinion. The personal assessment of the judge or the justice deciding the case.
Well, I think
because they say that this judicial activism is being used as a mechanism to check the excesses of the legislative or executive branch. Because there are times when the law itself is not sufficient to justify a ruling.
Really?
So the personal belief and interpretation of the judge or the justice is included in the decision to strengthen.
I think there's nothing wrong with it, but I will try it myself. One of these days I will try.
So you have not tried it?
I have not tried it.
Okay. So, how about judicial candor? Are you familiar with judicial candor?
Openness
In the decision. Because there are judges who are found to be guilty of dishonesty in the decision when they deliberately do not include the strong points in the case.
That's bad.
Yeah, that's it. They are found guilty of.
I believe in candor, definitely.
Yes. Okay. With your experience in the judiciary, what do you think can you contribute to further improve the image of the Supreme Court if we will be fortunate to be nominated and appointed to that court? What can you contribute?
My hardworking quality and my diligence, my competence. I think I have already proven myself through my 36 years in government service, 22 years of which have been spent in the judiciary.
Okay. My last question. What do you think are your strengths and weaknesses, both as a person and as a member of the judiciary?
My strengths, well, I can sit the whole day and read. That's why I make decisions faster than the others, I think. I don't mind sitting the whole day and the whole night studying.
How about your weakness?
What?
How about your weakness? What do you think is your weakness?
As a judge?
As a person.
As a person?
Which also affects the performance of your function as a justice.
I cry easily, if you can call it a weakness. But I do not involve my emotions when I decide cases. But I cry easily.
That's your
movies. Yes, even watching cartoons sometimes. When I watched Casper, I cried.
So how about the cases that you are handling? Do you allow yourself to be affected?
No, that's why I do not involve my emotions. Because when I was in the RTC, I was it was a special court to try drug-related cases. It made me tough during those 2 years.
Okay. So on that note, I have no further question for Justice Castillo. Good luck, Justice.
Thank you, Your Honor.
Thank you so much, Justice Lagman. This is a follow-up question. You stated a while ago that allowing the U.S. military bases again here in the Philippines is unconstitutional. What's your reason for saying so?
It is stated in the Constitution that there should be no military base unless...
yes, what is the exception? Unless concurred by the
Senate and the Congress.
Or if Congress requires
yes.
Approved by the people in a national
plebiscite
yes. Called for that purpose. Yes. Justice, how about this EDCA? The EDCA case is now pending decision by the Supreme Court. If you are one of the members and the ponente, how will you decide the case?
It's the enhanced enhanced defense cooperation agreement. It's an executive agreement. Well, practically, it's really like a base.
Ratified by the President, not by the Senate. So, is it constitutional or unconstitutional?
If, strictly speaking, no. Well, the Supreme Court can pass on the constitutionality of an executive agreement.
You are the ponente there. You are the ponente in the Supreme Court.
I think I would declare it unconstitutional.
Why?
Because, well, the U.S. personnel and troops are here because of that, and structures are being built to store their weapons. And
again, your basis is the Constitution.
Yes, Your Honor.
Remember, Justice, China is around,
yes,
ready to declare war of aggression against us. Would you not consider the fact that at least if the American bases are here, these Chinese people who are so aggressive will have a second thought? I think there will be no unanimous votes in the Supreme Court. This is my opinion. Yes. Because of this incident.
Because China is really a bully right now.
Precisely because of that. So thank you, Justice, and good luck.
Thank you, Your Honors.